I'm Jeff Rosen. I'm a law professor at George Washington University and a co-editor with Benjamin Wittes of Constitution 3.0, Freedom and Technological Change. People have long criticized the expectation of privacy doctrine for being circular, but technology is making it even less satisfying. So the circularity is obvious in the fact that our expectations of privacy depend on the amount of surveillance and incursion that we actually experience. And as technology makes those incursions more ubiquitous, our expectations diminish and there's a corresponding diminution in constitutional protections. But so that's just to say that in an age when if the government were to set flying miniature robots in the air and take out ads on the internet telling people that they might be spied on at all times by Open Planet, our expectations would diminish, and then the question is, should we have any residual protections? That was a question that the court in Jones didn't answer clearly. Justice Alito did seem to say that the relevant test was what citizens actually and realistically expected, but that seemed to set the stage for something like Open Planet to proliferate as long as it was done quickly and there were lots of warnings taken out about it. Technology has also changed our expectations because unlike in real space, although we may know in a theoretical sense that we might be viewed out of context, it's not our actual experience. So on Facebook, people expose stuff imagining that it's going to be basically viewed by their friends. And although they may be warned and told that the friends might share, or Facebook may have boilerplate disclosures warning that Facebook has access to the data, we don't actually imagine that it's happening, and then we're shocked and surprised and discomfited when Facebook ends up tracking us on the basis of conduct that we didn't imagine was going to be used for selling us ads as opposed to sharing with our friends. I think these are all additional reasons why we need to rethink the expectation of privacy doctrine. At some point, Congress or the courts or the mobilized citizens of the world are going to have to say, regardless of how much Mark Zuckerberg warns us that he is collecting and tracking our data, there is a point beyond which that becomes unreasonable and an indignity. And defining that point is tough, which is why the Supreme Court was understandably reluctant to specify the difference between surveillance 24/7 for a month and surveillance for a day. But unless that line is defined judicially or legislatively, then we're at the mercy of the technology. Yes, there are two really rich and provocative contributions about the future of neurolaw. And both of them begin with the idea that neuroscience is changing our traditional conceptions of criminal responsibility. So traditionally in Anglo-American law, you're held responsible for your freely chosen actions. Unless you literally act under duress, someone points a gun to your head, steal or else, or a defect in understanding that meets the legal definitions of insanity, you're held responsible for your actions. Neuroscience is now presuming to say that some people, because of their brain structure, are less able to control their impulses than others. If you have an overly active amygdala, which is the emotion control of the brain, and underactive prefrontal cortex, which is supposed to be the conscience which restrains the amygdala, then according to this defense, my brain made me do it, I couldn't conform my actions to law. And some criminals, convicted criminals in death penalty cases, are, as a matter of course, introducing this brain made me do it defense in order to argue, if not that their conduct should be excused, at least it should be, their punishment should be mitigated. So far, these defenses have not been all that successful. It's allowed in under the relaxed evidentiary rules that happen at sentencing, but juries are not buying it much. Nevertheless, according to some philosophers, the more we learn about the brain, the more we need to abandon our whole notion of retribution being an appropriate goal of criminal punishment. If it's true that we're really all slaves of our brain and that my decision to have a salad rather than soup for lunch was predetermined by my brain structure as well as by my, the way my mommy and daddy treated me, which was delightful, and other things that I can't control, then punishing me for my criminal actions seems no more fair than punishing a robot or for acting according to a program that it can't control. Instead, it might be appropriate to emphasize deterrence, to lock me up forever because we're afraid my brain is going to make me choose the bad action again. But blameworthiness is no longer appropriate. One of our contributors, Carter Sneed, made the very interesting point that this might not be great for liberal values or even for accused criminals. After all, if it's not appropriate to punish people based on their blameworthiness, it's also not appropriate to mitigate their punishment based on their acceptance of responsibility. And if you're really only concerned about restraining or deterring automatons from bad actions, you might have more capital punishment, not less. So it's not at all clear that the side of liberalism will be served by these brain made me do it defenses. But in addition to all that, brain science is calling into question not only our notions of responsibility, but also ideas about lie detection and also deterring people for future bad acts. So for lie detection, already apparently there are some fMRI scans that purport, when you show someone a picture of a place they've been, like a training camp in Afghanistan, to detect the brain lighting up in a particular way, and if they haven't been to the training camp, then it won't light up. And this is supposed to be more accurate than current lie detectors, although not accurate enough to be admitted into court under the Supreme Court's evidentiary standards. Once this gets ready for prime time, which it will soon, then you could well imagine picking someone off the street, giving them a brain scan. If their brain lights up to the training camp, off they go to indefinite detention. Now all of a sudden we're getting some very troubling questions about holding people accountable not for the acts that they've committed in the past, but for the bad acts they might commit in the future. And as the brain scans become more sophisticated and purport to show pictures of broken brains, people with more gray matter in their prefrontal cortex are supposed to be more predisposed to violence, might it not be possible to actually emphasize who is most likely to commit a bad act in the future, scan their brains, create a profile of the potential terrorist, and indefinitely detain people based on their future bad actions? This would gravely challenge the idea in Anglo-American jurisprudence that you should be held responsible for what you do, not for what you think, for your actions rather than your predispositions. But our two interlocutors, Sneed and Morse, struggled very interestingly with the degree to which this technology will challenge those traditional liberal values. It's so striking, isn't it, that although the idea that we should punish people for their actions rather than their predispositions seems to be a constitutional value, it's hard to point to a particular provision of the Constitution that guarantees it. The court has said that sex offenders, for example, may be indefinitely detained in the future based on their future dangerousness, because the connection between the past impulses and the future bad action are supposed to be so direct. This isn't viewed as a punishment, but a civil confinement necessary to protect society. Now, it's true that sex offenders have to be duly convicted of an offense before they can be indefinitely detained. But I think all of us can imagine that if the technology got good enough at predicting accurately whether people who hadn't yet committed bad acts in the future might, because of their brain structure, we could well imagine efforts to detain them as well. And of course the justification would be this is for their own good, this is civil detention, it's for the protection of society, we're not punishing them, we're just preventing them from acting according to the irresistible impulses of their brains. So if that were the case, what constitutional provision would forbid this sort of detention? The nearest analogy almost seems to be the Bill of Attainder clause, the constitutional provision that prohibits Congress from passing bills of attainder, which of course were the efforts to criminalize people based on their status, not their conduct. So if, say, I, Jeff, committed treason against the king in the old days, not only would I be a taint and I would be grotesquely disemboweled in a very ceremonial way, but and executed. But not only I, but my children would be strangers to the law, and they would have no ability to have offices of honor or profit, and they would be banished, and they wouldn't have the protection of the laws, and essentially they would be people without legal status. That would be visiting the sins of the father on the children, and the Bill of Attainder clause is designed to prohibit that. So you could say that if the brain scan reveals that I'm likely to commit bad acts because of the bad brain that I inherited from my father, it would be like a Bill of Attainder. But it wouldn't actually be a Bill of Attainder. Congress wouldn't have passed this the law that formally made me a stranger, an outlaw. So it's an analogy, but not a conclusive argument. And we could certainly construct constitutional arguments about that would call into question indefinite detention based on predispositions. You could say that this was a form of deprivation of liberty without due process of law, that due process requires that you're duly tried and convicted by a court before you're detained. But of course, the Supreme Court has signaled that when it comes to terrorism in the category of enemy combatants, a trial might not be necessary if you're found on the battlefield. So maybe the analogy here would be the violent brain is like being found on the battlefield. The point is not to resolve these issues, but just to suggest how dramatically an issue that you'd think would be clear under American law, namely you can't detain people for their predispositions, isn't clear, how the existing constitutional doctrine is challenged so dramatically by this technology.